Hey everyone, Rob Ryder again. It's November 5th, 2012. Continuing to talk about equity. And so really nothing's changed. The court of equity, what Chancery is, what equity is and is not. Um, Equity is for a remedy other than money. What legal title is and what equitable title is. And in law, whoever holds the legal title is the owner. In equity, whoever has equitable title is the owner. And equity is superior to law. In rem is law. It's directed towards a thing. So they're going to say that they have the legal title to something. They're holding the paper. Where in personam is directed towards a particular person. So somebody in law says he's holding a piece of paper to your property. You go to equity in personam, petition against the person who says it's his property and tell him, well, then you need to come here to equity and bring in your claim. Because law doesn't care how they got the legal title. It only cares that they have it. Whoever holds a title is the owner. That's what the law says. Unilateral contracts versus bilateral. Unilateral contract, again, is like a gift. It is not lawfully binding. There's been no consideration from the grantee of the contract. And merger of law and equity. I guess somebody thought I was trying to say they're the same. They must not have listened to the video. They're not the same. The administration is what's been merged. Got people wearing two hats now. Used to be there were separate courts. Walk in separate doors. Now you walk in the same door. But you need to make sure that you're asking for equity. So you're going to do a petition in equity. And so when we're all done, that's what I plan on getting to, is being able to write some words on a piece of paper for a petition in equity. It will be very simple, less than a page, using the maxims of equity and the facts of the case and the fact that they've already self-confessed to using color law against you. It's very easy to point out the defects in due process of law with the paperwork. The only problem has been, where do you take it to? So that's where we're headed with this. And again, if you can donate, there's my information, and I would certainly appreciate it. But this petition in equity, the interesting thing about that is, I found this one online. I just put in petition in equity into Google, and so, back some time ago, this is, I guess, in 2004, the Attorney General did a petition in equity. Now, normally when somebody's suing somebody, you just see the state up here, right? You don't see that there's an attorney listed. It's just the state of Iowa. Well, this time it's the state of Iowa, Thomas J. Miller, attorney. And so what this is a class action suit, and a class action suit happens to be something that's done in equity. The state of Iowa, the Attorney General, through the Assistant Attorney General, states as follows in support of this petition in equity. So what did he do? He put in a petition in equity. And it gave it an equity number. So it'd be interesting to know where this number leads to. What is an equity number? So the only reason I'm showing you this is, what we really want to do is be sure we tell them right up front why we're there, right? Let's get rid of the presumptions. Rebut the presumption before it starts. So, before we get to write anything, I just have so many things that I think that are pertinent that come from all these different pieces of paper I'm reading, and I can't read through them all, so I'm just putting key points on a few things that we're going to talk about over the next couple videos. And let's start with, this is really just things to do with equity, right? So the term equity is in general sense associated with fairness, morality, and justice. It is an ethical jurisdiction. On a more legalistic level, however, equity is a branch of law that was administered in the Court of Chancery. The origin of equity can be traced back to the existence of the 13th century reign of Henry I, yada yada. So, however, predominantly they all administered traditional and statute law. So that's what happened. The King's Bench, Common Pleas, Exchequer. It was all done in traditional, which is custom, and statute law, which is stuff that comes out of Parliament. And really, that's what is considered common law. But you see, we have two things that are being administered, two different types of law, lack of a better term. Let's say jurisdictions. You got an ethical jurisdiction and a law jurisdiction. Well, the ethical jurisdiction supersedes the law jurisdiction. So when they say you haven't exhausted your administrative remedies, right? It could be just because you haven't gone to the frickin' Court of Chancery, to the Chancellor, and had your law administered through there. So of these three courts, the Exchequer perform more than just judicial function, and according to somebody, it served as a government office, a modern-day treasury. So it's same as a treasury, or similar to a treasury. This court is not headed by a judge, right? So we're not talking about a courtroom. We're talking about the treasury. This court is headed not by a judge, but by a chancellor, a person equivalent to the Chancellor of Exchequer in modern-day Britain. So as a government official, the Chancellor oversees many departmental works, such as issuing of writs for the commencement of actions in the court of law. Even to this day, it is not possible to commence a legal action without issuing a writ or summons, or other kinds of writs, depending on the nature of the action, to the defendant. Right, so when they issue a writ of summons, it's supposed to have come from the Chancellor's office. If it did, it would have, well, I guess it did, because if the clerk is the Chancellor's office, I guess it did come from the Chancellor's office. When issued by the Chancellor, these writs are sealed with the King's seal. Oh, okay, well, they don't have the King's seal on it, so they weren't issued by the Chancellor. Evidently, the Chancellor occupies a very important position. He sits in a court, although he is not a judge, issues writs to other courts, and this places him above the judges, because he's going to tell the courts what to do with a writ. And what is more, he is the only one who can encrypt the writs with the King's seal, a symbol of monarchical authority. So who is the monarch? Right? Lord Jesus Christ. And so equity is actually the New Testament, and common law with custom is the Old Testament. And if you're a member of the Universal Church of Jesus Christ, sometimes called the Catholic Church, some people don't want to. Let's just call it the Universal Church, right? Well, then his law is superior to Moses' law. He came to perfect the law. Equity, however, enters injunctions or decrees directing someone either to act or forbear from acting. So what does equity do? It does injunctions. Often this form of relief is, in practical terms, more valuable to the litigant. For example, a plaintiff whose neighbors did not return his milk cow. I'm forgetting that. All right. The reason it's more practical is, in regards to your house, right? All you don't have is the title deed, the actual piece of paper, the title deed that the title company has. Well, why do they have it? Doesn't matter. The fact that they do makes them the owner. Even though you have the equitable interest, they are holding a piece of paper. And apparently there's supposed to be a mortgage and all these things, which we know isn't true. So what we're going to do is make them bring in the record and show that they have a reason to have the title, or give me the title back. The appointment in 1729 of the Master of Rolls, the chief, I like that word chief, right? The chief is always the head assistant. So it's not the elected people, it's the ones that just sit there forever, right? They've been appointed. The appointment so whoever is a chief is appointed. And then to sit as a second judge in certain cases. All right, now you think about this. To sit as a second judge in certain cases. Way back in the day, the earl and the bishop both used to sit in court at the same time and heard the cases together. Okay, so when is there somebody else in the court other than the judge? When we walk into their courts today, sometimes the clerk of the court is there, and she's a high candidate to be this chief chancery master, because She's at least the registrar of chancery, and if we could make registrar be the same as chief, that's pretty dang good. Or it could be a court reporter. Maybe. Right? Because they don't sit in there all the time. So there are times when there's somebody besides the judge and they're doing, something different. And a buddy of mine, Jeff, who did the confession, the audio we did, he talked to Roger Elvick here recently, and Roger mentioned a time somebody stood up at the defense table and read whatever they had to read, took 3 steps forward, and put it on the clerk's desk. And when he did that, the judge got up, took 3 steps back, and tossed her gavel back to the bench. And then left the room. So I don't know what that whole story is, but Roger Elvick's got a pretty interesting story that would fit in with this clerk of the court of record being the master of the rolls or the registrar of chancery or somehow tied to the chancery. And just the matter that it has chancery involved means the church is involved. Equity jurisprudence may therefore properly be said to be that portion of remedial justice, which is exclusively administered by courts of equity. Okay? If you want equity, you got to go to a court of equity. A court of equity is one which administers justice where there is no legal rights. Right? You don't have a legal right to your house because somebody else has the title. They have the legal right. Or legal rights, but law does not afford complete remedy. Okay, so you have legal rights. In that case, the cop that's bringing a charge against you into a court, what he's really trying to do is get you to, he's going to a court of equity. So this is traffic court, right? You're going into a court of equity where they're going to try to get specific performance to a contract that you signed. Now, the fact that you signed under threat, coercion, duress, none of that matters in a court of law. What matters is the cop's got the contract with your signature on it. So what you need to do then is say that he came with unclean hands, right? Well, I demand this be heard in a court of equity. In equity, everything is under oath. Rights, title, and interest. So, however, in general, a litigant cannot attain equitable relief unless there is no adequate remedy at law. That is, a court will not grant injunction unless monetary damages are insufficient remedy to injury in question. So if there's a bench warrant against your ass, well, money ain't going to help you, right? What you need is an injunction. If you're in jail, you need an injunction. Law courts can also enter certain types of immediately enforceable orders called writs, such as a writ of habeas corpus, but they are less flexible and less easily obtained than an injunction. Somebody in jail, you need to get an injunction. They're there because color of law was used against a living man. That's fraud. You need to take it to the chancellor. Another distinction is the unavailability of a jury in equity. The judge is the trier of the fact. The judge is going to make the decision all on his own. In the American legal system, the right of jury trial in civil cases tried in federal court is guaranteed by the 7th Amendment, but only suits at common law in cases that traditionally would have been handled by the law courts. So only in common law. Well, in common law, it says that they hold the title, they're the owner. You don't want a jury. You want to go to the trier of the fact, the chancellor. The question on whether a case should be determined by a jury depends largely on the type of relief the plaintiff requests. If you want money, you're going to get a jury. If the plaintiff requests damages, money, in the form of money for certain other forms of relief, such as return a specific item of property, the remedy is considered legal and a jury is available as the fact finder. So if they want money or a specific item of property, the remedy is considered legal. On the other hand, if the plaintiff requests an injunction, declaratory judgment, specific performance, modification of a contract, or some other non-monetary relief, the claim would usually be one in equity. You don't go to equity looking for money. You go in looking for an injunction, a declaratory judgment, specific performance, modification of a contract. Frustrated plaintiffs turned to the king, who referred these extraordinary requests for relief to the royal court called the Chancery. The Chancery was headed by a chancellor who possessed the power to settle disputes and order relief according to his conscience. Right? According to his conscience. Equity cases can't be understood as the only claims for which monetary damages was inadequate. All right? Don't want money. The most important remaining distinction between law and equity is the right to a jury trial in a civil case. Where the plaintiff seeks a remedy of money damages, the plaintiff is entitled to a jury trial. Again, where the plaintiff seeks a remedy that is something other than money, the plaintiff is not entitled to a jury trial. Excellent. Instead, the case is decided by one judge, right? Same thing said, just in a different way in a different place, but all the exact same things. What is equitable relief? It could be a restraining order or an injunction. An accounting may be requested by the plaintiff who seeks to know how his or her money is being handled. A trust or constructive trust can be ordered by a judge to place the care and management property of one person for the benefit of another. Declaratory relief is granted when the judge declares the rights of certain parties. Right? If they can't find any reason for the title company holding your title, the judge is going to declare it's your right and give you the damn title. And now you'll have absolute title. You have both the legal and the equitable. The effect of a declaratory judgment is set future obligation between the parties. Under the remedy of specific performance, a judge may order one party to perform a specific act. This type of relief is often used to resolve contractual disputes involving unique property, like land. The warranty deed that you signed with the grantor for the property, the guy you bought the property from, is a sales contract. Right? Now, most people haven't acknowledged it as the grantee, so it's not lawfully binding. But once you do, well, now that you want them to finish the contract and give you the title. You were never given the title because the contract was never completely executed. And so we want specific performance from the judge to make the seller give you the title. So now, I don't know if that means we got to go back against the grantor that was on the title deed. He had an agent. See, we all have agents, right? So who was his agent? Our agents are the ones who were supposed to do this. But at the end of the day, we don't need to know all this, right? The thing is, we need to know where to go, make sure it's an equity jurisdiction, give them our complaint, and have them help us. That's the way it's supposed to work. You were just supposed to take your complaint to the Court of Chancery and they would write a writ to fit your complaint. And that writ would be a subpoena. And that subpoena would say, hey, come on and bring in the records. In 10 days, bring in the records. And if you don't, they'll go arrest them. For example, the purchaser of the house may not wish to obtain money damages if the seller breaks contract for the sale of the house. This may be so because a house is considered unique and thus damages are irreparable. That is, it cannot be fully redressed by mere money damages. If a court agrees that money damages would be inadequate redress for the buyer, the judge may order completion of the sale to the buyer instead of money damages for the seller's breach of contract. Right? They're telling you, they're telling us what to do. Equitable contract remedies offer a judge an array of choices. Rescission, discharge all parties to the contract from the obligations of the contract. Restitution is an order directing one party to give back something he or she should not have kept. Reformation, an equitable remedy to a contractual mistake. Right? If the IRS says that you put in a false statement, well, you can say, well, I made a mistake. And since they seem to know what the mistake is, I want them to tell me how to do it correctly. If we want to mess with them. Equitable relief has long been considered an extraordinary remedy, an exception to the general rule of money damages. Okay, I'm going to switch gears. Talk about cestui use a little bit. Cestui V, cestui use, cestui trust. The cestui use and that is the trustee, is the person for whose benefit the trust is created. The cestui trust, and that's the beneficiary, is the person entitled to an equitable as opposed to legal estate. Thus, if land is granted to A in trust for B, B is the cestui trust beneficiary, A is the trustee or the use. The term, principally owing to the cumbersome nature, has been virtually superseded in modern law by the beneficiary and general law of trust. The cestui use, the trustee, and the trust, the beneficiary, were rooted in medieval law. Of course, they got three different definitions for trust, but the use is always the trustee. The trust could be the corpus, the trust could be the beneficiary, the trust could be the action that the trustee is supposed to provide. Were rooted in medieval law and became a legal method to avoid the feudal medieval incidence payments to the overlord while leaving the land to the use of another, who owed nothing to the lord. The cestui use trustee is the person for whose benefit the trust is created. The cestui use for whose benefit the trust is created. The law cestui tended to defer jurisdiction to a court of equity as opposed to courts of common law. So all these things I've been reading about trust, as soon as it starts talking about trust, it's talking about courts of equity. And so they're joined at the hip. So anything we have to do with the cestui that we've been made a part of from the Cestui Act is going to be resolved in a court of equity, not in a court of law. The cestui was often utilized by persons who might be absent from the kingdom for an extended period of time. So your all capital letter name is the name of a landed estate. It's your property. You have the equitable interest in it, but they're holding the legal title to it. Well, I think we should be able to go to a court of equity, appear before the proper magistrate. I'm back from across the sea. I'd like to claim my property. No longer an infant, age of majority, conscious, not a ward of the state, all the different things that we've talked about, or at least I have in the last year and a half. The trust has been defined in a technical sense as the right enforceable solely in equity. So that's what the trust is, a right enforceable solely in equity to the beneficial enjoyment of property of which the legal title is in another. So legal title's in a trustee, and the right enforceable solely in equity is in the beneficiary. It implies two interests, one in equity, one in law. Okay. The individual who hold the legal title is known as the trustee, the use, and another as a beneficiary known as the cestui trust, an old-fashioned expression for beneficiary of a trust. Equitable state. An equitable state is a right or interest in land which not having properties of legal estate, but merely the right of which courts of equity will take notice. Cestui use, he who to whose use the land is granted. Okay, so we get through all these things. The interesting thing is cestui. Where is this thing here? So cestui is shorthand for cestui use, the person in whose use the fiat was made. But when they say use, it meant the word work. Where is that? Here we are. This is what Pollock said, that the first step toward the law of agency, they noted the word use, as employed in medieval England. Law was not from the Latin juris, but rather from the Latin word opus, meaning work. So they weren't supposed to use it, they were supposed to work it. They were the tenant. And many reasons were given for the invention of the cestui use as a legal device. Today, this power would be called a power. So now today this power would be called power of attorney. So a cestui use, the cestui use person, that's giving them power of attorney. because you're the grantor and the grantee, so a trust is actually a deed between a grantor and a grantee, and the grantee is agreeing to do something for the grantor with the property to the benefit of somebody else. But they'd both have to sign the damn document, and they never sign anything. So, as I heard one guy describe it, he said a trust is an unexecuted use. And that's exactly what it is, because a use is between me and another person for the benefit of somebody else. But I would be the grantor, the guy putting in the res, and I would be going to the trustee, the person I'm trusting. We would have an agreement, and then I would give him the title. So, and then really interesting here, the Diocesan Record Office. So, originally in the United Kingdom, the title of Diocesan Record Office would frequently be referred to as church-owned diocesan registry or chancery. It would be where the episcopal registers, administration papers, and title deeds are. Modern usage, it generally refers to an approved repository frequently operated by a local authority, which has been specifically designated by the Church of England bishop for the collection and preservation of historic archives, both from the diocese and also local ecclesiastical parishes. So in England, I think they have these jurisdictions that are called a parish. And I think that's what they're talking about, the ecclesiastic parish, the little neighborhood, which would be the courthouse. Usually the Diocesan Records Office will now be within a city record office or ordinary county record office. So now the diocesan records are in the county or the city. The status of various Welsh county record offices as diocesan record offices, right? So county record offices are diocesan record offices, which are run by the chancery. And you can get this. This is off of Wikipedia, a diocesan record office. So I'm not going to read the whole thing. You can go look at it yourself. The county record office, United Kingdom. The term county record office usually refers to local authority repository, such as the county archives. Such repositories employ specialist staff to administer and conserve the historic and semi-current records of the parent body. They usually also preserve written materials from the great variety of independent local organizations, churches and schools, prominent families, yada yada. Archives may have been acquired either through donation or more generally by deposit of a long-term loan. So again, the Register of Deeds is a depository. When we take our deed and put it in there, we just deposit it with the county. And we gave them a frickin' legal title to it. Anything you put into the county, Register of Deeds, because register means to be deposited. And that's what you just did. The public access to central government archives, technically known as public records, and by extension local government records, were previously regulated by the accordance of these record acts. This one enabled the county repositories to be appointed by the Lord Chancellor to hold individually specified classes of public records, including local court records. So the Lord Chancellor, who works for the bishop, who is the bishop, he used to be the bishop, probably still is the bishop. They did this act in 1958 to allow the county to hold the court records, which would have normally been kept with the Lord Chancellor. Access to material within the record office is now regulated by these. So they got a Freedom of Information Act, although these do not necessarily cover privately deposited items. All right, so even when you go to do a public records search, you're not going to see everything because there's been privately deposited items. And I'm sure that's not working to our advantage. It's good to know they're doing it, but how do you get those? Well, maybe you have to go to equity and say, I demand they bring forward the records. Show me that they have a mortgage against the property that's not been satisfied. If it's been satisfied, then give me the damn title deed and give me back my securities, which is the promissory note, or actually it's gain because it's been converted, conversion and gain, and the payments you made. And any other remedy that the court feels is just. Such record officers are often also formally recognized by the Master of the Rolls as an approved repositories for manorial and tithe records. So there's the Master of the Rolls again. The Diocesan Chancery, this is on New Advent, the branch of administration which handles all written documents used in official government of the diocese. Known as the Diocese Chancellor. There's the Chancellor again. In many dioceses, the Chancellor exercises some faculties, which in other dioceses are exclusively reserved to the Vicar General. For the correspondence, registration, care of archives, such as Administration Bureau, are provided with a secretariat or a chancery. All right, so some places I got to go look and see what a secretariat is. And this is New Advent. This is Diocesan Chancery, so easy enough to find. Oh, what else was there on here? So in keeping with these recommendations, the Diocesan Chancery consists of a certain number of officials named by the bishop. In the United States, England, and Australia, there are usually, besides the Vicar General, a Diocesan Chancellor and a Secretary. So, since everybody believes the Vatican runs everything, then it would make sense that the church is involved. And so when you look at canon law, there's ways to put in claims into canon law. But it may be that the church, obviously, you think about it, well, they can't be out being seen doing this stuff, or a bunch of people in the world go crazy that the church is trying to take over. But they have all the records. And if we go to the chancellor instead of the black robe priest, and the chancellor works for the vicar general, there's a good chance that we're going to get some equity. So that's it for this one. Got one more like this, and we'll get on to trying to come up with some words to put on paper to go try a few things on some simple matters such as a foreclosure. Even if you're not in foreclosure, you just want to get your title to your property. If somebody's in jail, if you have a court case, if they've issued a bench warrant. We're not looking for money, we're looking for justice. It's a whole different ballgame. And we'll look at the 14 maxims of equity and see what we can use them for. All right, we'll see y'all later.